Good day everyone, I am Ellen Joy Alalor, BE Scream 4B, and today I'll be presenting Rule 117 of Rules of Criminal Procedure, which is all about the motion to quash. A motion to quash is a written pleading filed by the accused before entering a plea, asking the court to dismiss the criminal complaint or information because there is a defect in form or substance, or because prosecution is barred by law. It is a procedural safeguard ensuring that no person is tried under a defective or unjust criminal charge. At any time before entering his plea, the accused may move to quash the complaint or information. The motion must be filed before arraignment, that is, before the accused enters his plea of guilty or not guilty. Once the plea has been entered, the accused is deemed to have submitted the trial and the court assumes jurisdiction over him. Any defect not raised beforehand is waived, except the jurisdiction and double jeopardy. After arraignment, a motion to quash is no longer allowed unless the ground involves lack of jurisdiction or double jeopardy. The motion to quash shall be in writing, signed by the accused or his counsel, and shall distinctly specify its factual and legal grounds. It must be written, signed, and must clearly state the reason for quashing, both factual and legal. The court resolves a motion to quash only based on the complaint or information and the grounds stated in the motion. Oral or vague motions are invalid. For example, an attorney files a motion stating the information fails to allege intent to gain an essential element of theft. It is valid because it precisely states the defect. Remember, the burden is on the accused to show that the information is defective or illegal. This is the heart of the Rule of 117. It lists valid legal grounds for quashing. First, the facts charged did not constitute an offense. It means even if everything in the information is true, it does not describe a crime. If the essential elements of a crime are not alleged, the case is void. The court looks only at the information, not at evidence to determine this. Second, the court trying the case has no jurisdiction over the offense charge. It means that the case was filed in a wrong level of court, either MTC, RTC, or Sandigan Bayan, or etc. Each court can only hear certain cases depending on the penalty or nature of the offense. Jurisdiction over the offense is determined by the law, not by agreement of parties. Third is the court has no jurisdiction over the person of the accused. It means that the court never legally obtained authority over the accused. Jurisdiction over the accused is acquired through arrest, surrender, or voluntary appearance if non-court proceedings are invalid. If the accused voluntarily appears in court, it is equivalent to submission to jurisdiction. Fourth, the officer who filed the information had no authority to do so, meaning the person who signed or filed the information was not legally authorized. Only a public prosecutor or a person authorized by law may file a criminal information. Without proper authority, the filing is void from the start. Next, letter E. It does not conform substantially to the prescribed form. The information lacks essential details required by Rule 110, such as the name of the accused, offense, date, place, or acts complained of. From the facts may be amended by the prosecutor under Section 4. Next is the letter F. State that more than one offense is charged except when a single punishment is prescribed. The information includes two or more crimes in one charge. An information must charge only one offense to avoid confusing the defense exception. For example, complex crimes of Article 48 of the RPC. Remember that duplicity may be waived if not raised before pleading by Section 9. Letter G. the criminal action or liability has been extinguished. It means that the right to prosecute is gone due to that amnesty, prescription, double jeopardy, or payment of fine. Once liability is extinguished, the case cannot proceed even if evidence is strong. Letter H. The facts charged constitute a legal excuse or justification. The information itself shows that the act is lawful or excused, for example, self-defense. These grounds rarely appears because prosecutors usually avoid alleging justification in the information. Next, letter I. The accused has been previously convicted, acquitted, or the case was dismissed without his consent. It means the accused cannot be tried twice for the same offense. The right is protected by Article 3, Section 21 of 1987 Constitution. If the motion to quash is based on alleged defect which can be cured by amendment, the court shall order that an amendment be made. It means if the defect is fixable, the prosecutor must be given a chance to correct it. But if the amendment changes the nature of the offense, a new case must be filed. Section 5. If the motion to quash is sustained, the court shall order that the accused be discharged unless held or another charge. It means if the court grants the motion, the accused is released unless there's another valid charge pending. For example, the case is quashed for lack of jurisdiction. The accused is freed unless he's also facing another valid case. Remember that the case may be refiled if the grounds is curable but not if it involves double jeopardy. An order sustaining the motion to quash is not a bar to another prosecution for the same offense unless based on double jeopardy. It means a dismissal after motion to quash doesn't prevent refiling except when double jeopardy applies. Only when the ground is double jeopardy does the dismissal become final and permanent. If the accused was convicted, acquitted, or the case was dismissed without his consent, he cannot be prosecuted again for the same offense or an offense necessarily included or including the ones charged. Double jeopardy protects not just the same crime but also include offenses such as serious or slight physical injuries. If the dismissal was with the accused's consent, it does not bar refiling. For example, accused himself asked to dismiss the case for a lack of evidence, prosecution can refile later. Remember that double jeopardy applies only when dismissal is without the accused's consent. Last one. Failure to assert any ground before pleading shall be deemed a waiver except for jurisdiction, double jeopardy, or that the facts charged do not constitute an offense. If the accused doesn't trace the defect before pleading, he waives it, except for the three fundamental defenses. For example, an accused doesn't object to duplicity before pleading not guilty. Later, he can complain that two crimes were charged. Always file a motion to quash before arraignment to preserve your rights. To sum up it up, this rule serves as a shield of fairness and due process, making sure that every criminal charge brought before the trial is valid and just. Thank you for listening, and I hope you gained a clearer understanding of how the motion to quash upholds justice in our legal system. And that will be all. Thank you and God bless.